Good afternoon, everybody. I'm Nick Green, I'm a Court of Appeal judge, and I'm chairing this afternoon's session. I'd like to thank you all very much for joining this seminar on mass data breach claims hosted by Brick Court Chambers. As you will know, the issue of data breaches is attracting a great deal of attention at the moment. Almost weekly in the press and in the media, there are reports of another asserted data breach. High-profile instances over the last few weeks have included Google, Facebook, BA, and EasyJet. During my career at the bar, I spent many years litigating cases where one of the issues was as to the remedies available for breaches of EU law. This included the right to injunctive relief and to damages for unlawful legislation in the factor-tame litigation, which I spent almost 10 years in. Later, I spent a long time acting for brewers and pub owners, fending off claims for damages from tenants who alleged breach of the competition rules. That included Courage and Korean, a case which addressed the question of available remedies at the level of the European Court and the House of Lords. Now, over the intervening period, such claims have become a very familiar part of our legal landscape. Now, the purpose of today's session is to consider the nature of the remedy available for data breach claims. The leading authority, as you will know, is Lloyd and Google. The Court of Appeal gave judgment last year, and the appeal in the Supreme Court will be heard next year. As we know, this case requires the courts to consider the parameters which must be met in order for mass data breach claims to be successfully brought as representative actions under CPR 19.6. And of course, from the perspective of defendants, it identifies the threshold issues which are likely to be the basis upon which defendants will seek to resist such claims. Now, it goes without saying that as a sitting judge, I have absolutely no views on any of this whatsoever, but I will listen with very great interest to what our speakers have today to say about these issues, and I'm delighted to welcome our three panelists. First of all, Victoria Wakefield, Queen's Counsel. She is instructed for the claimant in Lloyd's and Google, and she's been in its case from the inception, along with her solicitors from Mishcon, who I know are part of our audience today. For Victoria, the case combines her considerable experience and specializations in data protection law. For instance, she was in the Supreme Court last year in the death penalty protection case, El Ghazouli. And collection actions, for example, she was also in the Supreme Court very recently, last month, in Merrick's and MasterCard, which is the leading competition case in the field of collective actions. Sarah Abram is an immensely experienced barrister at Brick Court. She seems to have been in about every collective action you can think of, including that relating to rail fares, trucks, and Ro-Ro claims. She also combines experience of data breach law with commercial competition and EU law, and over the past few years has been involved in many summary disposal applications, jurisdiction challenge, and funding disputes in connection with cases such as CRT and power cables. Matthew Kennedy is a very busy junior at Brick Court. He specialises in data law, competition law, and general commercial. It's a rapidly growing experience in both ordinary but also collective actions. For instance, he's instructed for one of the defendants in the trucks collective proceedings in the competition appeal tribunal. Our first speaker is Victoria, who's going to address at Lloyd and Google the issues which arise concern how to bring mass data breach claims, and in particular whether it is possible to bring opt-out claims in English law. The answer to that given by the Court of Appeal in Lloyd and Google is that you can bring that sort of mass opt-out action for damages using CPR 19.6. I think to many people that conclusion was somewhat surprising because 19.6 has lain dormant for many years. For many years, it was assumed that it was relevant essentially to bodies such as unincorporated associations. Many of you will know that there was an unsuccessful attempt to awaken that beast in the competition law context in Emerald Supplies, but as Victoria will now explain, Lloyd and Google has changed all of that. Victoria.
Thanks very much, Nick. So the first thing I should say is, because I'm instructed in Lloyd and Google and it's ongoing live litigation, I obviously need to be entirely partisan and adversarial in everything I say today. So I'll be very much towing the claimant Richard Lloyd party line. The facts of Lloyd and Google can be fairly shortly stated. It's a claim on behalf of over 4 million Apple iPhone users. In outline, the allegation is that Google tracked the internet activity of those iPhone users during the period between August 2011 and February 2012. It then collated that information and used it for targeted advertising to its very significant commercial advantage. That tracking and collation was secret and was in breach of Google's publicly stated position, which was that the Safari browser on Apple iPhones was set to block that sort of activity. And that particular conduct by Google is normally referred to as the Safari workaround. So a couple of quick observations at this point. First of all, there's a dispute between the parties in respect of Google's knowledge of the Safari workaround. Either they did it deliberately, or they say accidentally, but it is common ground and accepted that it was secret and unknown to the users and that it was contrary to public statements at the time. The second quick observation is that there have been various other pieces of litigation and regulatory action concerning the Safari workaround, all of which have settled. The most famous of those, perhaps in this jurisdiction, is Biddle Hall, which settled after the Court of Appeal held that damages should be available for distress without pecuniary loss for breach of the DPA 1998. So the starting position is that we've got a large class of people in respect of whom we've got a pretty compelling data breach. So what do we do? How do we bring a claim on their behalf? And in particular, as Nick just said, how do we bring an opt-out claim? Now, I'm sure that everyone watching this knows what opt-out means and what opt-in means, but if you humour me just for a moment, opt-out is a claim in which the whole class participates, save those who opt out of the claim. Opt-in is a claim where each individual claimant has to opt in order to be part of it. And the availability of an opt-out mechanism is a game changer because of the difference in take-up rates. Just by way of example, and I know that Matt is going to address Morrison shortly, but in the Morrison's case, that's a GLO, so that's an opt-in mechanism, and you have to choose to become part of the claim. So Morrison's 100,000 employees' data was affected, and only 10,000 joined up to the GLO, just 10%. If one were to bring an opt-out claim on behalf of that class, of course, the class would be 100,000, subject to those who decide to exercise their right to opt out. So pausing here for a minute, opt-out claims, unsurprisingly, give rise to particular issues. An obvious issue is the risk that the class is being taken advantage of. And so those concerns give rise in turn to particular requirements in respect of the infrastructure for those claims. Now, I don't have time to get into this in great detail today, but by way of example, first of all, proper notification is key to class legitimacy. The court has to know that the class members have had chance to exercise their right to opt out. So that means they have to have known that the claim was being brought and known that they could opt out of it. Secondly, instructions will be given by the representative claimant alone. There'll be no contact between members of the class and their legal representatives. So that means that the court has to have confidence that the representative is acting in the best interest of the class. So it really matters who the representative claimant is. It also matters that he has people to assist him or her in proper decision making. And in Lloyd and Google, we've done something which has now become best practice really in the competition collective action sphere, which is to have a panel of advisors who sit behind the rep claimant and can assist them with difficult decision making. Thirdly, a third example of that sort of infrastructure is if an opt-out claim succeeds and gives rise to an aggregated award of damages, so a single sum in respect of a class, it will need to be properly administered. It will need to be properly distributed. There'll need to be proper evidence provided by class members to demonstrate their entitlement to that sum. Also, the North American experience in the US and Canada indicates that take-up rates will not be 100%. So there will be an undistributed amount of damages which is left at the end. And so again, one has to think with an opt-out, what does one do with that residue? As recorded in the High Court judgment in Lloyd and Google, we make two proposals. Either it's applied C-prey, so to something similar to distribution to the class, or it's returned to Google, the reverter, which is again something that happens in North America on occasion. So those are some of the points which arise in respect of opt-out claims in general. But how do you even bring an opt-out claim outside of the competition sphere where you have primary legislation? The answer, which we now know, following the Court of Appeal, is in 19.6, the classic representative action. So the mechanism there is that where more than one person has the same interest in a claim, the claim can be brought by one of those persons as representative of all the others, and the whole represented class is bound by the judgment, absent court order to the contrary. So in a data claim such as Lloyd and Google, how do you bring the claims on a same interest basis? The other side to say that there is a significant variation between each affected person, and one can immediately think of some of those variations. They may have had different volumes of data affected. One person might browse multiple sites each day for hours at a time. Another might browse once a week, only one site maybe. They may visit sites of differing degrees of sensitivity. One person might just search for Spanish villas and other innocuous topics. Another might search for sites which are terribly embarrassing and relate to their hideous personal proclivities and darkest interests. They may have been very differently affected by the targeted advertising. One person might just themselves receive a fairly helpful advert for a Spanish villa. Another person may have lent her phone to her husband so he can check something. Up pops a targeted advert revealing said hideous personal proclivities, and her most private thoughts are suddenly revealed to someone who she didn't wish to know them. So it's true to say that if each of those claimants were to sue individually, their claims would be different. What we've done in Lloyd and Google is to sue for the lowest common denominator. So we identify that part of the claim which is the same across the class, and we sue only for that. And we disavow any reliance on any individual facts affecting any individual claimant. Instead, we sue only for that minimum. Now, the High Court, it's fair to say, did not like that approach at all. It said it was artificial and essentially a device. But the Court of Appeal said it's fine. And they said if there is a common part to all of the claims, and they said there was, then there's nothing wrong with suing only for that common part. And if an individual doesn't like it, they're free to opt out and sue for the full amplitude of their loss. So I turn now to one of the key respects in which Lloyd and Google has developed or clarified the law, namely the sort of damages for which you can sue in respect of a data breach. The entitlement to damages under the DPA, the old DPA 1998, is set out in section 13, and it provides that a person who suffers damage by reason of a contravention of the Act, the DPA, is entitled to compensation for that damage. What constitutes damage? So we know it includes pecuniary loss, we know it includes distress, but those sorts of damages are inherently likely to be individualised and to require individual proof, and so they're not much use to us in 19.6. So we sued for two other forms of damage. Damage either on a loss of control basis or user damages, what used to be called root and park, hypothetical release damages. And we're seeking a flat per capita amount, the same for each class member. The High Court said that neither of those two bases were available under section 13, but the Court of Appeal disagreed. It agreed with us that loss of control damages must be available. Now, I'm not going to descend into some kind of detailed legal lecture at this point, you'll be very pleased to hear. But it's basically because of Article 8 of the Convention and Article 8 of the Charter, the specialised data right. And under those articles, where those rights are infringed, provided it's a non-trivial infringement, that should result in compensation. So that's at the Strasbourg, Luxembourg level, but it's also supported domestically by a case called Gulati, which is the phone hacking case. The tort in that case was misuse of private information. But the Court of Appeal in Lloyd and Google said, well, that tort in section 13 derived from the same core rights to privacy, the two Article 8s. They form two parts of the same European privacy protection regime. Now, in Gulati, the phone hacking case, damages were awarded even when no use was made of the hacked information and the person hadn't even known the hacking had taken place. So if you imagine some of the information would have been very juicy and interesting, would have been about drugs and affairs and pregnancies and whatever else. But some of the voicemails were just, pick up a loaf of bread on the way home, please. You know, they were of no interest to anyone. Nevertheless, the mere fact of the hacking, even though the information was never used, the mere fact of the hacking attracted £10,000 as the base rate tariff compensation. And that was for the loss of control over that data. Now, the beady-eyed amongst you, and those with the defendant hat on in particular, will have spotted that the availability of these sorts of damages is circumscribed by the breach being not trivial or not de minimis. And that's because of the Article 8 MPI route of this kind of damages. What does that threshold mean in practice? So the Chancellor, giving the judgment of the Court of Appeal, said that that threshold would undoubtedly exclude, for example, a claim for damages for an accidental one-off data breach that was quickly remedied. So that'd be the wrong side of the line. But that is far from this case. On the case pleaded, every member of the represented class has had their data deliberately and unlawfully misused for Google's commercial purposes without their consent and in violation of their established right to privacy. So our case, clearly the right side of the line, but a helpful indication about what might be the wrong side. And Sarah, I think, is going to address in a little more detail how that threshold might work in practice. As I said earlier, the alternative basis on which we sought damages was a user basis, root and park, and Matt will be considering that alternative basis shortly. But I'll just flag here that the Chancellor was tentatively positive about them. The High Court didn't like them at all. But he said he saw no reason in principle why it was not at least fairly arguable that damages might be assessed on that user basis. So it certainly lives to fight another day. So just pulling the strands of this section on damages together, we succeeded in identifying that damages are available for data protection breaches, even where there is no claim for pecuniary loss, even when there's no claim for distress, and that they can be sought on a lowest common denominator basis.
And so, Tori, that kind of gets us you over the same interest threshold with respect to damages, but it didn't stop there in terms of satisfying that test, did it?
No, it didn't, exactly. So there are other elements of the same interest test that also needed to be satisfied. First of all, there was a prior legal question that the other side said, well, maybe rep actions can't be used at all in any damages claim, and there is ancient authority to that effect, though it has been subsequently doubted. And the Court of Appeal agreed with us that there was no such bar, provided you met the requirements of 19.6. There is an additional requirement within necessary part of 19.6, which is that there aren't separate defences which can arise in respect of different members of the class. That is a requirement, but the Chancellor held that it was satisfied in our case. And there's another distinct requirement under 19.6 that comes through the cases, which is identifiability of the class. So in order for the jurisdiction under 19.6 to arise, the class must be identifiable. That means that at every moment in the litigation, you must be able to tell whether you are part of the class. So you can't define the class in a way where you will only know if you're part of it at the end of litigation. You can't say the class anyone who suffered loss by reason of X breach, because then you'd only know if you were in it at the very end. Now, it's true that in Lloyd and Google there's an issue about identifiability. Again, we lost at first instance, and again, we won in the Court of Appeal. And the Court of Appeal held that a combination of the personal knowledge of the class member about whether they had that phone, what they looked at, and whether they changed the default settings, combined with the fact that that'll then be testable by data received from Google following disclosure, was enough to satisfy that condition. But that is a freestanding condition. And then once the jurisdiction under 19.6 has arisen, the judge has a discretion as to whether to let the claim proceed. And the Court of Appeal indicated the factors which it thought were legitimate for a judge to take into account when exercising that discretion, and a factor which it thought was illegitimate. So amongst those legitimate factors included, if the judge had formed a view that lawyers benefited from the claim, he could take that into account. Obviously, the judge was very wrong to take that view in this particular case, but it would have been a legitimate consideration. But he could take into account the litigation being costly compared to the per capita recovery, and also the absence of complaints about the conduct. But by complaints, that means things like regulatory action or other cases, because we know that the factor that was wrong for the High Court to take into account is whether there is any kind of authorisation between class member and representative, and the judge shouldn't take that into account. And that takes me back, of course, to the opt-out point with which I started. It's a real reaffirmation and assertion of the opt-out nature of 19.6. And the Court of Appeal finished its judgment by exercising the discretion itself to order that the claim could go ahead as a 19.6 rep action. Now, of course, we're now headed to the Supreme Court, and all three questions are up for grabs again: the damages question, same interest question, and exercise of discretion. So we'll have to wait and see whether the Supreme Court agrees with the Court of Appeal, as of course it should. And that, Nick, is all I wanted to say by way of overview for Lloyd and Google.
That's it, yes. Yes, Lloyd and George isn't the only data protection case that has caught the attention of the Supreme Court. Just a month or so back, I think it was on the 1st of April, I don't know whether that's appropriate, the Supreme Court gave judgment in Morrison supermarkets and various claimants, which, as its name suggests, involved numerous claims. Now, as I recollect, the High Court had made a GLO in connection with the claims in that case. Matt, what does Morrison's add or take away to the position in the Court of Appeal in Lloyd and Google?
I think the short answer, Nick, is that Morrison's doesn't really add anything, but equally it doesn't take anything away. It's, as you say, it's not a 19.6 rep action claim, it's a GLO claim, and equally it doesn't consider either of the bases of damages which are an issue in Lloyd and Google. It's not loss of control and not user. But what it does do is it does sort of indicate the different types of factual circumstances which give rise to breaches, and also highlight some of the different sort of remedial mechanisms that you can use to remedy those breaches. And so that's what I want to look at today. Now, I'm sure you're all familiar with the decision in Morrison's, but it might be helpful just to recap it quickly. Morrison's is obviously a supermarket, and as Tori said, some 10,000 employees brought a claim against them in respect of data that was payroll data that was leaked on the internet. It comprised their names, addresses, gender, dates of birth, phone numbers, national insurance numbers, bank details, salaries. So quite a comprehensive suite of data, and obviously giving rise to some very severe identity theft risks and associated risks. It had been published online by a Mr. Skelton, who was an auditor within Morrison's internal auditing team. He'd been tasked with giving the payroll data to KPMG, the external auditors. He'd done that, but he'd made a copy of the data and he'd uploaded it to the internet and then posted links on various websites telling people where it was. He then sent a CD to a number of newspapers saying, or purporting to suggest, that he'd found the data online and he was concerned about it. The newspapers flagged that to Morrison's, who contacted the police, and Mr. Skelton was arrested, and I think got 8 years in prison. Seemingly he had some sort of grudge against Morrison's, which had arisen out of relatively minor disciplinary action that had been taken previously. So a GLO was started in the High Court, and Mr. Justice Langstaff held that Morrison's were vicariously liable for Mr. Skelton's breach of the Data Protection Act 1998, for his misuse of the claimant's private information, and for his breach of his duty of confidence. Morrison's appealed to the Court of Appeal. That was dismissed, and then Morrison's appealed again to the Supreme Court. Now, there were three issues before the Supreme Court. Firstly, was Morrison's vicariously liable for Mr. Skelton's conduct? Secondly, did the Data Protection Act exclude the imposition of vicarious liability for statutory torts committed by an employee data controller? And thirdly, whether or not the Act excluded vicarious liability for the common law offence, the misuse of private information, and the equitable breach of confidence. The Supreme Court held that Morrison's was not vicariously liable, and Lord Reid's judgment includes a very comprehensive tour of previous highest authority on that issue, which is useful if you've got a tort law exam tomorrow, but probably not of particular interest for most of you today. What's likely of a bit more interest is what the Supreme Court said in answer to the second and third questions, which was that the DPA did not exclude the imposition of vicarious liability for breach of the Data Protection Act by an employee, or for misuse of private information or breach of confidence. And so in a sense, what you have with Morrison's is it gives with one hand and takes away with the other. It's doubtless sort of a relief that an employee with an axe to grind won't have you vicariously liable, but equally you can think of much more mundane circumstances which could give rise to a breach of the Data Protection Act by an employee data controller, and that may actually be more common. And so the risk of increased liability for companies, I think, it is there in the decision.
Perhaps, Matt, Morrison's is a case that's strongly driven by its own facts. It's taken out of the mainstream by this employee vendetta angle. But it is striking, I think, nonetheless, that there's not just one monolithic type of data breach case.
I think that's exactly right, Sarah. That sort of takes me back to where I started, which is to sort of pick up on some of the differences. And I'd like to look at three. I think the first is the most simple. It's just looking at the sort of factual circumstances which can give rise to a breach. And obviously, to try and give a comprehensive account of what those are would be something of a fool's errand. But I think we can think in terms of broad categories, insofar as that helps us to think about broad types of risk and mitigating those risks. And for sort of my own purposes, I think you can divide recent data breaches into two types. The first is what I call breach by design. And as Tori mentioned at the start, there's a dispute in Lloyd and Google about whether or not Google deliberately created the Safari workaround or whether or not it was an accidental action. And I'm not involved in that case, and so I won't sort of weigh in with any views about what's more likely. But it's certainly fair to say that there are lots of companies, and an increasing number of companies, whose value is driven by the data they have and the data that they share with others. And I think this creates an acute tension between profit motive on the behalf of those companies and data protection. And I think this in turn makes it more difficult for us to advise. And to sort of put it shortly, it's difficult to tell someone how to sail close to the wind. And I think in terms of mitigating those risks, it may only be a judgment from the Supreme Court upholding the Court of Appeal in Lloyd and Google and the spectre of an aggregated award of damages that's sort of sufficient to steal the minds of companies like this. And so in a sense, time will tell. The second category I call rogue actors, just to make it sound a little bit more exciting than perhaps it is. And this is perhaps the more familiar type of data breaches, where a company's hacked by a third party, and then the information is posted on the internet or sometimes on the dark web. Well-known examples are the Equifax breach, British Airways, and EasyJet. The rogue actors involved may be involved for their own personal gain, or you do sometimes see state actors being involved. And if you look at some of the papers for the Equifax claim, you see that the Department of Justice actually indicted 4 Chinese military personnel in connection with that breach. And I suppose the third and more esoteric version is the ex-employee with an axe to grind, as we saw on Morrison's, but hopefully that's relatively uncommon. Now, in terms of advising on risks, this is an easier category of breach. The goal is very simple: keep hold of the ball. And so we focus on security systems and IT systems and making sure that those are up to scratch with applicable industry standards and industry best practice. So the second difference takes us back down to the million-dollar question, or perhaps the billion-dollar question, which is damages. And Tori's already addressed the principles that underline loss of control, so I'll turn to the question of user damages. This too has recently been considered by the Court of Appeal in a case called Morris, Garner and OneStep. And once again, Lord Reid carried out a comprehensive review of the authorities. Lord Sumption offered a slightly different review of those authorities, and Lord Carnwath got somewhere in the middle. Once again, I think there's not time today to sort of embark on a discussion of who's right and who's wrong, but I think 3 points in particular are worth highlighting. The first is Lord Reid's articulation of the principle underlying these damages. And to be perfectly honest, it's not particularly clear, but he said that there are certain circumstances in which the loss for which compensation is due is the economic value of the right which has been breached, considered as an asset. And he said that these circumstances exist in cases where the breach of contract results in the loss of a valuable asset created or protected by the right which was infringed, as for example in cases concerned with breach of restricted covenants over land, intellectual property agreements, or confidentiality agreements. And that's all rather gnomic, I think, but on my reading it boils down to this: if you have a right that allows you to control use of something, in our case data, that right has economic value in itself, and damages should be awarded to reflect that economic value. Turning to the measure of damages, and something you may be familiar with, is that sometimes it's described as the hypothetical release fee measure. and that is the sum that the claimant could hypothetically have received in return for releasing the defendant from the obligation that they failed to perform. So in our case, the failure to perform obligations under the DPA or the GDPR. And the thing to note is that the negotiation is entirely hypothetical, which can lead to certain issues, as flagged in the Marathon asset case. The economic value of the right, and this is the third point I want to come on to, and therefore the economic value that you ascribe to the hypothetical release fee can be considered, Lord Reid says, to the value of the wrongful use. And so you look at the benefit to the wrongdoer, you can look at the profits the wrongdoer has made as a result of the breach in order to value the damages. And I think that what you can see is that there are some similarities between user damages and loss of control damages. Both look at the question of control and how one values the question of control. But I think that there's potentially an important difference between the two, and that rests or lies, if you like, in the third of these principles, which is looking at the benefit to the wrongdoer. And if we go back to our two categories of breach, our breach by design and our rogue actor breach, I would suggest that user damages is more likely to be relevant or useful in the first category of case, where what you have is a company with a business model which derives benefit from use of data and therefore likely derives benefit from the wrongful, deliberate or accidental use of data. By contrast, in your rogue actor case, yes, the third party is likely to derive economic benefit from the breach, but it's quite unlikely the defendant itself is going to derive any economic value. Quite the contrary, it's just a massive headache for them. The third difference is that which Nick highlighted in his introductory remarks, which is to look at some points of difference between GLOs and rep actions under 19.6. I want to highlight three. I think the first is what I'll call the commonality requirement. And as Tori has explained, in a rep action, you have to show that the class members have the same interest. Under a GLO, that's watered down a bit. And so the test is common or related issues of fact or law. The second point of difference is that you can look at individual circumstances, and there's a procedural mechanism under GLOs whereby you can file a group set of particulars of claim, and then you can have schedules annexed to that which highlight relevant differences for individual claimants. And then the final point is, rather than having a single trial with a single rep action which binds all others, absent a court order to the contrary, in a GLO, and you saw this in Morrison's, what you have is you have test or lead claims that go forward first and try and resolve the issues in that way. So in a sense, the GLO, like Morrison's itself, gives with one hand and takes away with the other. The commonality requirement is less stringent and potentially easier to get over that initial threshold, but the other aspects of it, the administration of the case and the case management, are at least initially more burdensome and more costly than a rep action. And so, Nick, that really concludes my whistle-stop tour of the relevant differences that are thrown up in this area at the moment.
Thank you very much, Matt. So we've had two judgments of this, or two cases in the Supreme Court, Lloyd's and Morrison. Lloyd's yet to be determined. There are a series of other major data breach cases which are litigating. Sarah, what sort of themes are emerging out of this for both claimants and defendants?
Nick, you're right that the data so far available on data breach claims is limited, and yet it is a growing body, and there are some themes that we can already see emerging. I think the first is the early challenge to the viability of the claim. Looking at this from a defendant perspective, it's often welcome to have an early opportunity to have a look at whether the claim's really going to stand up without having to jump through hoops of disclosure and witness statements and, of course, a trial. And those of us who do a lot of competition litigation will recognise that over the 15 years when cartel damages claims really took off in this jurisdiction, the first areas in which the key principles were mapped out were in the area of summary judgment and jurisdiction challenges. And my tip in data protection is that the same will be the case here for exactly the same reasons. We see that in Lloyd and Google, that arises in the guise of a contested inter partes application to serve out, excuse me, which is a jurisdiction challenge by any other name. There was also a jurisdiction challenge in Vidal Hall against Google, so another case about the same data breach. Going further back, Emerald Supplies, as Tori mentioned earlier, not a data breach claim, but an attempted representative action that encountered an early strikeout application as well. So that's one theme. Another example goes to how the bringing of these claims is funded. Now, publicly available information, restricting myself to that, suggests that these claims are so far being funded in two ways, either by external third-party funders or effectively by the firms of solicitors who are bringing the claims on a conditional fee basis. A key difference, though, arises there with the competition collective proceedings regime, because in this area, in the data protection area, there is no inbuilt upfront certification stage at which the lawfulness and the appropriateness of funding arrangements can be assessed by the court. And that is potentially of real significance. To take trucks as an example, with which both Matt and I are very familiar, the respondents there argued that the proposed class representatives shouldn't be authorised because their funding arrangements involved unlawful damages-based agreements. Now, as it happens, that argument didn't find favour with the Competition Appeal Tribunal. But the question that it raises with broader relevance is whether and when a similar argument could be heard by a court considering a proposed representative action or a GLO. A further emerging theme is whether the geographic scope of claimant classes in representative claims now specifically, setting aside GLOs for a minute, in the context of representative claims, whether the geographic scope of claimant classes may be limited by the same interest requirement. We can see from Lloyd and Google, from the judgments, that that claim is brought on behalf of class members who are resident in England and Wales. And likewise, the three individual claimants in Vidal Hall were all domiciled in England. According to the Court of Appeal in Lloyd and Google, the touchstone for the same interest requirement is whether the members of the class have a common grievance and whether common defences are available. Now, this raises something of a dense thicket of legal issues when you start thinking about how geographically diffuse the members of a class can be while still getting over that same interest threshold. The central focus for that, I think, is what the applicable law is for these claims, how you go about determining it. Are the claims, for instance, governed by the law of the claimant's place of residence? Now, if that's the case, where claimants are resident in different states, there will be different laws, different aspects, different legal rules applicable to the claims of different claimants in the group. So to take an example, there might be different national rules on limitation. And that is regardless of the fact that lots of the legislation on this within the EU, and within the UK as well, comes from an EU superstructure. It still leaves space for the laws of the member states where they can differ. Another good example where the law may differ according to residence of the claimants is in the context of jurisdiction. Now, under the CPR, for instance, claimants in England and Wales could bring a claim in the courts of England and Wales on the basis of the damage suffered within the jurisdiction gateway for service out. Claimants in other parts of the UK or in other countries couldn't rely on that gateway. They may very well be able to rely on other gateways under Part 6. Does that matter? Does that prevent them from satisfying the same interests criterion as a homogenous group, or does it introduce too much heterogeneity in the words of the competition context? And finally, in terms of the themes that are coming into focus already, unsurprisingly, a stark information disparity between claimants and defendants is coming into focus. In Lloyd and Google, the High Court and the Court of Appeal reacted differently to the fact that the class representative can't at present list the members of the representative class. So Mr. Justice Warby considered that this was a fatal flaw. Neither disclosure from Google nor self-certification could fill that gap, according to his approach. The Court of Appeal, on the other hand, thought that either approach would be satisfactory. Now, that information asymmetry, in the terms that will be familiar to any of us that has ever read a competition cartel damages pleading, is going to be a key theme of data breach litigation. In that context, we can see from the competition sphere that courts are going to offer a degree of latitude to claimants in putting together claims because they recognise that they'll have limited visibility regarding the alleged infringement. There's no reason why the same shouldn't apply in the context of data protection. In particular, when no ICO decision is yet available at the time that a claim is got up, it might be difficult for potential representatives even to identify the personal data affected by the breach fully or with clarity. Now, what's interesting about the Court of Appeal judgment is that in line with other areas of law, it suggests that a pragmatic approach will be taken, but it still leaves open the question of whether there will be circumstances in which this information asymmetry kiboshes the claim.
And Sarah, I think one of the things that's very exciting here, or exciting for us at least, is because it's such a nascent field and it's just getting off the ground, there are so many issues like those that you've just outlined, really just scratching the surface of what's there, I think.
I think that's really right. There's a really rich seam of issues that haven't yet been considered or explored. Nick mentioned courage and crean and factor tame in his introduction. I think that's really apposite because the world of data breach litigation is reminiscent of the world of EU law litigation maybe 20 or 30 years ago, the world of cartel litigation maybe 10 or 15 years ago, when many of the key questions hadn't been mapped out. And in some cases, they hadn't even been identified. We didn't even know what they were. Let's take 3 examples of that. First, I think one of the key uncertainties in this field, and you referred to it earlier, Tori, is how much financial value will notionally be attributed to the loss of control. So in Lloyd and Google, the claimant had suggested that £750 per class member might be an appropriate order of magnitude. But why not £50 each? Why not £2,000 each? Where there's no, I see you approve of one more than the other, Tom. Where there's no financial loss and there's no established scale, of course, in this area, like there's an Ogden table in the context of personal injury claims, what methodology should the court be using to translate the loss of control into a monetary award? One aspect of that question is when a breach is going to be too minor for a claim to be brought at all. It was common ground in Lloyd and Google that there was a de minimis threshold below which it would be appropriate to refuse an award of loss of control damages. But the Court of Appeal doesn't set out a test for how low that threshold is, either in terms of the monetary value of the loss of control or in terms of the facts of the case. You could see that various touchstones could be used to gauge whether a case is too trivial. The court could, for instance, consider the consequences of the breach for the individuals affected. So, for instance, they could consider the likelihood of identity theft or fraud. So, a breach where unencrypted current credit card details are taken might be particularly serious. By contrast, a breach of some relatively public types of personal data might be inherently less likely to lead to serious consequences. The court could also look at the inherent seriousness of the breach itself. How long did it last? How blameworthy is the data controller or the data processor? By that measure, even a deliberate breach might not be trivial, even if the personal data taken was less sensitive or less extensive, because what would matter on this basis was the blameworthiness of the breach, the seriousness, the inherent seriousness of the breach. Of course, it's not necessarily a straight choice between the two factors either. Both might be relevant. A second example is how far the same interest test will impose a straitjacket on the course of the rest of the proceedings. Now, as Tori said, the Court of Appeal in Lloyd and Google has said that the class members must be victims of the same wrong and the defences must be available to each of them. Beyond that, it didn't matter how colourful their internet browsing history was. So my innocuous and yet committed searching for second homes in France is on this measure equally worthy of compensation than someone trawling the outer reaches of the dark web on a habitual basis. The Chancellor's judgment in Lloyd and Google seems to say that this requirement permeates through the whole case. So all class members are held to the lowest common denominator of damages for the lowest common loss of control. But let's hypothesize that one could establish by reference to objective fact, objective, externally ascertainable fact, not individual evidence, that there are subgroups within the representative class who demonstrably suffered a more serious loss of control. The question then would be whether a particular subgroup should be prevented by the same interest criterion from claiming their full loss. In the CPO context in competition law, there's no suggestion that the requirement that the claims should raise common issues requires the value of the loss of each class member to be the same. Well, you could say, so what? The wording of the two tests is different, so why does that help? But arguably, the two touchstones are there to serve essentially the same function. That is to say, the purpose of them, both in both contexts, is to group together claims that you can efficiently try together because they raise the same legal issues. So on that basis, why not have people with different levels of loss, different groups of people in the same class or different subclasses who have the same legal interest but have suffered different consequences? A third example is what happens if there are two proposed representative actions in respect of the same data breach with the same or overlapping classes. Now, this hasn't happened yet in the data breach field, but there must be a realistic prospect of it doing so. Tori, Matt and I are all very aware of the upcoming carriage disputes in the trucks and FX collective actions. One would assume that courts looking at carriage disputes for data breach claims might well take inspiration from the path of collective competition law actions. Certainly, it surely can't just be a question of a race to the courthouse. In FX, the Competition Appeal Tribunal has given judgments in March, which starts to consider what factors are relevant to determining carriage disputes. But there's a great deal of uncertainty about how these disputes should be handled, even in the CPO context, where there's a specific purpose-made statutory regime. So I think stepping back from all of that, the bottom line is that, as you say, Tori, there are many critical issues which remain to be identified and to be decided, and the lack of statutory framework and case law mean that the courts are going to have substantial latitude. In Rumsfeldian terms, I guess that these are only the known unknowns. There's much more to come. Nick, that's all I wanted to say on that aspect.
Thank you, Sarah, very much. We've got time for some questions, and a number have been emailed through. Can I pick up a question which has been sent through in relation to quantum of damages, which may relate to what Sarah was just talking about in relation to de minimis thresholds and lowest common denominators, but it really relates to the Lloyd case itself. And so I think this is really a question for Victoria. A question comes from Pratik Swiker, a boys Schiller Flexner. I'm just going to read it out because I think it makes the point very well. What is the basis of Mr. Lloyd's quantification of damages at a flat amount of £750 per claimant? Were variables such as duration, gravity, number of devices, volume data, and so on relevant to the calculation?
So obviously I can't say much about underlying thinking in the Lloyd claim, but I can answer aspects of that question. First of all, no, it doesn't reflect variables, or at least not a variation between different members of the class. It's all that lowest common denominator. And so you have to look to see the common element across all class members. And in Google, of course, the most important thing really for us is the quality of the breach, thinking of the two different types of factor which Sarah was just addressing. In terms of the figure of £750, which featured in our letter before claim and is set out in the High Court judgment, I think all I should really say is if you look at the cases which the Chancellor referred to in his judgment as domestic authority supporting Gulati and supporting his approach to Gulati, he sets out various instances of domestic decisions where, although they've never been put in this way, in fact, they've given awards of damages where there hasn't been distress and there hasn't been pecuniary loss. So in particular, awards of damages for Article 8 based claims involving children, when children were unaware of their image being published, for example. And there is, of course, some of the Strasbourg Authority as well. So if you look at those cases, you see awards of damages of 10,000, 15,000, 2,000, 3,000, and 750 in Halliday. And so there you see the kind of gamut in cases historically, but of course it's never been put in quite the way that we're putting it now. I'm sorry, that's a bit of a cagey answer, but I hope that's enough to go on.
Thank you. Whilst you're on your feet, not on your feet, Victoria, a couple of other matters which have been raised. Lloyd and George was under the old DPA in 1998. Has the GDPR exerted any impact upon this? Would it be different under the GDPR?
It wouldn't be different under the GDPR, no. So in fact, the Chancellor refers to the GDPR in his judgment and says, well, even though I shouldn't construe earlier legislation by reference to subsequent legislation, he says, I do actually find it quite instructive that in the GDPR, not only do you have an article in the same terms as Article 23, and that again, it now specifically says you're entitled to non-material as well as material damage. Well, so what? That could just be distress. But then in the accompanying recital, the example is given of loss of control over data. That's the example of non-material damage. So if anything, the position is a fortiori in the GDPR, and in fact, the Chancellor referred to it. So no, the cases will keep on going on that basis.
One more question for you. If damages are reduced by reference to the lowest common denominator, doesn't that mean that many members of the class would be, by definition, significantly undercompensated? Isn't that a logistical problem, or is that just simply part of the course?
It's part of the course. It's part of the course. So it's true that it troubled the High Court, and one can well see that ideally, of course, one would have everyone, all data subjects who possess these rights and deserve to have a way of vindicating their rights. After all, they've been given them by legislation. It does seem unfair that people can't sue for the full amplitude of their right. But for people who feel that they do want to do that and they can realistically do that, they can opt out. And for the others, I'm afraid that at the moment, this is the only show in town. And we do have to bring it on a common interest basis. So for people who do want to, like Ms. Vidal-Hall, go it alone, brilliant, do it. And for everyone else, it does have to be on a same interest basis.
Thank you. And the next question concerns the difference between user damages and loss of control damages. So I think this is for Matt. User damages and loss of control damages might be understood as being based upon the economic value of the data and the economic value of control over the data. And those were distinctions referred to by the Court of Appeal. If that's right, what's the difference between them?
Thanks, Nick. I think that's absolutely right. You see that in the Chancellor's judgment in Lloyd and Google, where he talks about the economic value of data as an asset and the value of control over that asset. And equally, as I said in my remarks earlier, that's exactly what Lord Reid says. And I think the key difference is the third of the three things I picked up on, which is about the relevance, if any, of the benefit to the wrongdoer. And as I said there might be some practical significance to this in the context of litigation of this type, where if you have a case that concerns a defendant to whom data is sort of inherently valuable and they're likely to have profited from the breach, then user damages may be a more promising or a more sort of useful or fruitful basis on which to go. And as Tori said, the Chancellor has been quite tentatively positive about that, and that's going to be one of the most exciting things to sort of see develop. There's a question mark about whether or not they're restitutionary or compensatory. Lord Reid makes very clear that they're compensatory in the Supreme Court in Morris, but I think that the key point is that you can look to the profit, and that provides you with more guidance or perhaps a solution to the quantification problems that Tori was discussing just a moment ago.
And just one other question coming for you, Matt. If you were starting a data claim afresh, so let's go right back to basics, what do you think are the factors which would help you decide whether you go down the representative action route or down the GLO route?
I think the first sort of issue that we're all waiting for is the Supreme Court in Lloyd and Google, and that obviously has a big impact on whether or not you can whether it's viable to bring 19.6 claims. But I think even without knowing that, there are certain differences which lend themselves to GLOs and rep actions respectively. two of the issues I raised earlier. One, the possibility of including claimant-specific elements within a GLO, and that's an important difference over or advantage over rep actions. And if that's something that's important to kind of getting the claim off the ground or getting it kind of across the finish line, then I think that favours a GLO approach. And I think secondly, I raised the issue of the case management and logistical problems, if you like, that are potentially raised by a GLO, and the need to issue individual claim forms, the need to have separate particulars or potentially have separate particulars. And I think that that means that where you have a class size of the Morrison scale, so 10,000, a GLO it is probably feasible. And you see that in some of the old industrial disease cases, what sort of sizes of case can be done. And so the sort of widespread nature or otherwise of the breach in question is another important consideration. But it's important to note that there are big data breach claims that are being brought as GLOs, and Mr. Justice Warby, who sat on Lloyd and Google, made a GLO back in November 2019 in respect of the British Airways claim, and that is a very large claim of a piece with other claims of this sort. So I think it's not the case that one's better than the other, but there are different considerations at play.
Thank you. We've got time for a couple more questions. For Sarah, quickly, do you expect the ground rules for data breach claims and competition collective claims to diverge over time? Is there any reason why they should be different?
Well, I think that raises a really interesting point, actually, in two respects. The first is that when CPOs were brought in, they were expressly brought in for competition claims on a kind of quasi-trial basis, with an idea that they might be expanded. This might be a candidate area for such expansion. And the second point, just briefly, is that I wonder whether the imperfect overlap, the kind of Venn diagram between the same interest test under 19.6 in particular and the commonality test in the CPO regime may offer real opportunities for exploitation of the gaps between the two. So if you're a defendant where the 19.6 regime is narrower, then you stick to that. Where the competition regime with its established case law offers you particular opportunities to take points on funding and so on, where people have gone before you making those arguments, then you take advantage of that. So I wonder whether there'll be parallel tracks that never quite converge.
Thank you. One question from me, perhaps banging the drum for the Commercial Court and the Chancery Division. Do you think we're going to get claims which are effectively extraterritorial, where the data breach has occurred abroad and where people think it's useful to litigate in the UK High Court?
I think that would be one of the most interesting areas in this of litigation here, because the kind of obvious starting point is classes who are resident in England and Wales because of the jurisdictional and same interest issues. But what we need, I suppose, in this field is a Provimi type case to explore what the boundaries are within which we can bring these claims and within which these claims can be disposed of at a summary level, as the defendants sought to do in Provimi. So establishing the ground rules for the initial engagement, and I'm sure it won't be that long before one of these comes to an initial determination stage.
Thank you very much. So, well, we're running out of time, ladies and gentlemen. And I'm going to draw this session to a close. I think listening to the debate today has highlighted that there are a very large number of important issues at stake and still to be decided. You know, the extent to which our legal system should be capable of dealing with mass breaches. To what extent are the defences available to these sorts of claims? Do we have an appetite for US-style claims? Do we have that sort of culture? Do we wish to import it? Defendants who are faced with a wholly new approach to substantive law and procedure will be keen to exploit and explore the interstices of different areas of law, and there is, I think, a lot of work for the courts to become involved in a lot of decisions that we will have to take over the next few years. So I would like now to thank, on your behalf and on my behalf, all the speakers for what I found to be extremely interesting, and I'll be straight off to the listings officers to get myself on the next case. They're so much fun. So thank you all very much indeed. We've hit the witching hour of 2 o'clock, so I'm going to bring this session to a close. Thank you all very much. Thank you.
Thank you.
Thank you.